What's up, everybody? Welcome back into another episode of The Lawyer You Know, and we are back talking about Karen Read because it just seems this case never stops, and we have been hearing about the defendant's motion to dismiss for some time now. It was impounded at first, which means sealed, but now we get a redacted version of a 150-page document. Most of those are exhibits, but we're going to go through basically the entire motion, go through what's in there, and then what's not, because there are a lot of redactions, and what we can learn from them and what we can see as far as the content of the redactions is really concerning and something I didn't necessarily know about literally until I read this document. There's a lot of things in this motion to dismiss we knew were coming, but the things we didn't know were coming are pretty concerning too. So we're going to talk about all that and see if we think this actually has a chance to get any of the charges against Karen Read dismissed. So we are going to start here on, what page is this? Page 4, I think, where they get to the actual statement of the facts. First 3 pages are basically the defense saying, hey, guess what, court? The prosecutors are supposed to be ethical. They're supposed to be reasonable. They're supposed to seek justice. They're supposed to do what's right. They cannot violate the criminal defendant's rights. They can't hide evidence. They can't destroy evidence. They can't do things like that. And that's exactly what they've done in this case. They have destroyed evidence. They have hidden evidence. They have given us inverted videos. They have had discovery violations where they say something doesn't exist and then eventually they give it to us. They have changed statements based on impeachment evidence. They've given us information with Higgins on the phone that they said didn't exist and flies in the face of what some of their witnesses said. All of that stuff is Brady. All that stuff is prejudicial, and therefore you should dismiss this case. And we're going to get into the details as we read the actual motion itself. I think it's always great to start a video like this on a tense case with some birthday wishes. Chris K says, happy birthday, John. Thanks for being the Know Your Lawyer guy's best friend. We know it is a tough job. Some days much tougher than others, Chris. I must say, if I could speak for John here, yes, it was John's birthday this week. Now he's finally my age again. Took him a while to get here. But let's get into the statement of facts. Ms. Read is accused of the following crimes. Okay, we don't need to read that. Commonwealth altered the course of the first trial in this case by destroying exculpatory evidence, withholding exculpatory evidence, and interfering with the jury. So this interfering with the jury, when we get to that section, you're going to see a lot of it's redacted, but some of it's not. And I want to be careful. I don't want to read between the lines too much. I don't want to try to guess at what happened. But there are some cases cited. There is some context given where we can see, how legitimate is this and will this really have an effect on the outcome of this motion and this case, right? But that is concerning, and I don't really know what the details are. And I could be wrong, right? You guys know. Have my own caseload at my firm. And, we cover a lot of cases on this channel. So I don't have perfect recall on every single little detail of every single little case. You guys that really dive in, or you have your 1 or 2 or 3 cases that you're all in on, sometimes you know more than me about some of these details and these facts. My recollection is the redactions were only supposed to be things that dealt with the federal protective order. So I thought that would be with expert witnesses, federal investigation, things like that. So I don't really know why tampering with the jury would be redacted unless, maybe it's a juror's name or identifying information that's already been impounded and that's why it's redacted here. Or does it have something to do with the federal investigation? Again, that's something I don't know, so I don't want to go too far down that rabbit hole. But that was a major, I was like, oh, wow, okay. There's going to be things in here I don't know about. There is no cure short of dismissal with prejudice that can remedy the serious constitutional and statutory violations that have occurred in this case. The facts relating to the respective misconduct and discovery violations are set forth below. I also think, by the way, because that language kind of mirrors what Alessi said in the hearing. And I think that this was drafted for the most part prior to everything that's gone on the last 2 weeks, and that is continuing to go on. And there's not a lot from the last couple hearings in this. And I kind of feel like they could have added even more as to what's going on now, the language used, maybe some of the inconsistencies or misrepresentations stacked on top, potentially. At least those are the allegations of the defense, but not a ton of that in here. A lot of what we have seen in some prior hearings, though, is included. So first, facts relating to the destruction and withholding of exculpatory CPD video surveillance footage. This court is aware of the critical importance of the video surveillance footage from the CPD on January 29, 22. The Commonwealth has produced dribs and drabs of various clips of surveillance video obtained from the CPD's ExactQ Vision DVR system from January 29th without any accompanying reports, evidence logs, or other documentation regarding the recovery and chain of custody of this evidence on at least 4 separate occasions. So I don't want to do a ton of this because we have a lot to get to, but things like this trigger in my mind questions that you guys have had on, Twitter, Instagram, whatever, other arenas where I haven't been able to answer it on video. And people have asked, what's the difference with the Commonwealth saying video doesn't exist and then it coming forward, and the defense saying we didn't pay ARCA and then a paid invoice comes? Well, the difference is if you actually stroke a check to ARCA, you should know if you paid ARCA or not. Now, the defense described the situation where it's possible that things are happening without each defense counsel knowing, which I understand. But when it comes to the Commonwealth and they say something doesn't exist and then they do put out a little clip of video, they're like, oh, we didn't know it existed. And then it appeared somehow. So we turned it over, Judge, because we're trying to turn over everything that we need to because it's all Brady. So that's why we turned it over. So they are literally sticking to the story of they just don't know where this stuff comes from. It just appears. And when it appears, they turn it over. We don't have a, huge 12-hour uncut video clip of the surveillance that night. I don't know why they don't. They don't know why they don't. But that's why the judge is not necessarily hammering them every time, because they just say stuff like, we didn't know. We don't know. Here's what we have. And we can't produce something that we don't have. And we can't tell you something that we don't know. And that's been their story a lot. Relevant discovery orders. On February 2nd, 22, the defense filed defendant's emergency motion for preservation of evidence, including the preservation of all physical evidence, such as video surveillance footage. Now, I don't believe that parentheses was in the actual motion. I could be wrong, though. It's Exhibit A if anybody wants to go look at it. I don't think we're going to have time to get through the exhibits today. With the Stoughton District Court. At February 2nd, 22 hearing, ADA Lally stated in open court that he had reviewed the proposed order and had no objection to it. That same day, the district court issued a preservation order for all physical evidence, which includes video surveillance footage. In other words, 3 days after John O'Keefe's death, the Commonwealth was aware of its affirmative obligation to preserve any and all video surveillance footage in its possession, custody, or control, which included the CPD and or Massachusetts State Police, and ADA Lally was required to notify law enforcement of this order. On September 16, 22, Ms. Reed's case was transferred to Norfolk Superior Court following her June 2nd and June 9th indictment. The defense filed a separate motion to compel the production of certain outstanding discovery, including all crime scene photographs and or videos taken in connection with the case. So again, lawyers, especially defense lawyers, when you don't have the information and you don't know what does or does not exist, or whether or not there were cameras or whether or not they're working, you're broad. You ask for everything as many different ways as you can. Physical evidence, photos, videos. You should be getting the videos at this point. On October 5th, this court granted the motion to compel in part and ordered the Commonwealth produce all video evidence and metadata associated with the videos on that date. So that's back in October of 22. And if you want to go even before that, it was February of 22. And new video clips are still coming out in 2025. That's a problem. Is it enough to get the case dismissed? We'll talk about what the different remedies are that could happen with something like this and why some of them just obviously don't make sense. Dates of production and facts relating to the discovery and constitutional violations. The CPD's video surveillance footage has been in the Commonwealth's possession, custody, and control since January 29th of 2022. So there's something redacted here. I don't know what it is. Notwithstanding this court's order, this court's October 5th, 2022 discovery order compelling the production of all video evidence and accompanying metadata in the Commonwealth's possession, the Commonwealth and its agents withheld this exculpatory evidence from the defense for more than 2 years, failing to disclose even the first incomplete batch of footage until the eve of the first trial on April 4th, 2024. So that right there, to me, stands out like a similar situation to what we're dealing with for Alec Baldwin. Because theoretically, the defense, one way or the other, found out about the potential ammunition. So if the judge wanted to, like Judge Cannoni in this case, where the video footage came in, it was used, they dealt with it. That's what the judge could have done in that case. All right, well, now that we have the ammo, no harm, no foul, let's keep the case going. That's not what that judge did, obviously. And that ammo wasn't a smoking gun for the defense. It wasn't going to absolutely mean Alec Baldwin is going to prove his innocence so easily. It wasn't, what a layperson may think of exculpatory evidence, which is, video proof, rock solid proof the defendant didn't do it. That's not what exculpatory evidence is. It's much broader than that. And this video absolutely could have an exculpatory definition to it. It was going to impeach multiple Commonwealth witnesses, and the defense believes could potentially prove the condition of the taillight, or who was around the taillight, or the timing of different things. So it absolutely fits in with the exculpatory definition, and it wasn't turned over. And I'm glad the defense gave us this timeline, because you just see how bad it is. February of 22, they say turn it over. October 5th, motion to compel. You're ordered to do it, or you could potentially be sanctioned as a lawyer if you don't follow through with the court's motion to compel. And the first batch isn't given to you until April of 24. But again, when prosecutors say stuff to judges like, we didn't have it, judge, we didn't know, we just found it. As soon as we got it, we gave it to them. How are we supposed to give something to them that we don't have? That you start to understand exactly how it works and how much evidence may be out there that prosecutors either have access to or should know about or do know about that defendants never do. And there are cases cited throughout this motion that are just situation after situation where that happens, and it sucks. But that's the rules. That's how it's gone in this case. The Commonwealth has now produced 4 separate incomplete batches of video surveillance footage recorded on January 29th. April 4th, production. So now we're going to go through some of those different productions, see the different productions, maybe, try to figure out why. And juror affidavits of dismissed jurors' reasons. Jurors' affidavits of dismissed jurors' reasons. Okay. Will we ever see what's been redacted? It's possible. They can unredact it. Will they? I don't know. Renee's mom. If this is denied, can they appeal? It'll be part of their appeal after the trial if they lose. It's not something that they're going to do an interlocutory appeal about. I don't think. Brisby. The biggest difference between this and Baldwin, a judge who cares about prosecutorial misconduct. I mean, listen, we're not just going to compare that judge to Judge Cannoni. When it happened, we said this is something a lot of judges would not have done. So the fact that she did it, we were all well done to that judge. All right. On the eve of the first trial in this matter, the Commonwealth for the first time disclosed woefully incomplete CPD video footage, which consisted of video from the CPD main driveway and CPD Sallyport front wall cameras of January 29th. Curiously, the Sallyport front wall footage omitted a 42-minute interval at the precise time the SUV arrived at the Sallyport garage. And how we look at this stuff, and it's I've even started to do it in this case as well. I've started to just continue to talk over these horrible things that happen, that if it was an individual thing that happened in a case, I'd be pounding the table for. But if you are in control of something, you were ordered to preserve it, you were ordered to produce it, and parts of it go missing and it's damaged and it's not good, that should be held against you. The court should be at the very least giving an instruction to the jury that this is the Commonwealth's video. This is the video from law enforcement. And the fact that these portions are deleted can be held against them. We give those spoliation instructions in Florida all the time, where it's like, this is a pool where my client drowned and we told them, don't do anything to this pool. We need to have somebody come test it. And what did they do? They drain it. They repainted it. They retiled it. You can hold that against the defendant in this case. None of that was really done here. Or I said we were going to talk about the remedies later. Let's just do it now. Another remedy is you can't use that evidence. Let's throw that evidence out. Well, the problem with that is, especially if it's Brady or if it's exculpatory, the defense wants to use that evidence. So what kind of a remedy is that for the defense? If it's like, oh, you violated discovery, you didn't turn this over in time, so you can't use it. It's like, well, we didn't want to use it anyway, judge. It's very different than if they were to disclose an expert late and it's like, well, you can't do it because you blew the discovery deadline. It's like, well, that hurts because you want to obviously call that expert. But when it's exculpatory evidence, that's no punishment for the other side. Sallyport frontage wall. Okay, the missing footage from the Sallyport wall camera would have captured a close-up of the condition of the SUV's rear taillight upon arrival at the CPD Sallyport garage, B, the individuals who had access to the rear taillight, and C, whether anyone removed the taillight material from the SUV before the first piece of taillight evidence was recovered at 34 Fairview. All very important things for anybody that watched the first trial. The condition of the rear taillight of the Lexus SUV at the time it entered law enforcement's custody is perhaps the most critical and highly contested issue in this case. It is astounding and convenient for the Commonwealth that this seminal time frame is missing from the Sallyport front wall camera footage. Moreover, the data was not preserved in a forensically sound way in violation of the February 2nd preservation order, which means that the defense has been denied the ability to determine whether the Commonwealth deleted, altered, manipulated, or otherwise lost critical video evidence in its possession that it was obligated to preserve. So again, the reason I like an instruction from the judge is the jurors usually like the jurors usually respect the judge, they trust the judge. So when the judge says something, it usually makes them raise their eyebrow. When there's all sorts of other things going in the case, sometimes it can be a really important thing that the judge says this. But sometimes judges will say, you know, Mr. Jackson, you can figure it out and get it out on cross-examination. Fine, but that's clunky because then you have law enforcement officers be like, well, I don't know how it works. I don't know how, I'm not the tech guy. I don't control that. This was just given to me, and it's not a clean thing where this chunk is missing. It shouldn't be missing. And the fact that it's missing is very convenient for this side, right? You can make those arguments. It would be better, in my opinion, if you could actually get a judicial instruction. April 10th, 2024, the Commonwealth filed its certificate of compliance. So on April 10th, the Commonwealth filed its certificate of compliance in which ADA Lally certified to this court 6 days before trial, the Commonwealth, after exercising reasonable inquiry, and that's important, and due diligence to the best of their ability, disclosed and made available all items subject to discovery, which obviously includes all the video clips. April 10th, okay, this representation was patently false. It strains credulity that ADA Lally, in light of his actual knowledge about the preservation order and existence of extensive Sallyport videos, would represent to the court and to the defense that after reasonable inquiry, he disclosed and made available all known discovery material in his possession, custody, control at a minimum, rather than mislead the court. The defense, ADA Lally, was obligated to inform the court and the defense that there was outstanding video surveillance footage. And then we have a section here that starts with a big redacted section, but April 23rd, the Commonwealth produces inverted video mid-trial in violation of Rule 14 and attempts to use that video to defraud the jury into believing that no one approached or touched or otherwise manipulated the right rear taillight of Miss Reed's SUV. And we have to realize it's a defense motion. Defense gets to make their arguments. The defense gets to put their reasonable inferences together. So this is how they see the evidence. This is what they believe happened. And this is what they're arguing to the court happened. That this was done intentionally, fraudulently to misrepresent facts to the jury. If the court agreed with this, she should sanction law enforcement and the prosecutor's office and everybody, right? If she believed it and saw it this way. We know that's not how she sees it. On April 23rd, the Commonwealth produced additional footage from the CPD Sallyport back wall via share link entitled Additional Sallyport Video Download Link. No flash drive was presented to the defense. The Commonwealth subsequently exploited their mid-trial disclosure of this video surveillance footage as part of their attempt to convince the jury nobody approached or touched the right rear taillight of Miss Reed's vehicle after it entered the Sallyport. ADA Lally craftily elicited testimony from Sergeant Buchanan that this interior Sallyport camera was an accurate depiction of the Sallyport and the SUV when it arrived at the CPD on January 29th, and that, as seen in the video, no law enforcement officer approached the right rear taillight. Again, there's different ways you can do it. Words are important. Is it an accurate, is a mirrored image an accurate image? I don't think anybody's asked themselves quite that question until this case came, at least as often as it's been asked since. By the way, when you file your certificate of compliance with discovery, especially as a prosecutor, you better be right. And if you give anything later, you should know, number one, if I really need it and I want to use it, there's a chance the judge might just strike it because I've filed my certificate of compliance, meaning I have given over everything I plan to use at trial. And if it's going to be bad for me and you give it, the judge should reprimand you and cause a big stink about it. Because if you also remember about this first trial, both sides wanted to continue the case. And this may have been one of the reasons that the defense just got this video on the eve of trial. And then during trial, they're getting more video. Almost evidence that this case in this trial should have been continued. Everything was not turned over the way that it should have. On cross-examination, however, Sergeant Buchanan's testimony was exposed and profoundly misleading at best and perjurious at worst. It became apparent that the video surveillance footage displayed on direct examination was inverted and a mirror image of reality, critical facts which neither ADA Lally nor Sergeant Buchanan saw fit to inform the court, defense, or jury. In other words, this video made on the left side of Miss Reed's SUV appears to be the right and the right appeared to be the left. Therefore, the video presented to the jury as fair and accurate appeared to show a person, Trooper Proctor, standing near the left rear taillight of the video when in fact, Trooper Proctor was standing near the right rear taillight. Now, it didn't come out quite that clean at trial, but generally speaking, I think that's exactly how it ended up coming out. And putting forth that, like Lally would have to say, I didn't know it was inverted, or I didn't realize it, or it was my bad. I didn't realize it. He would have to say that, because to know it was inverted and ask the questions the way that he did would be eliciting false testimony and putting it before a jury to potentially wrongfully convict somebody, which no prosecutor should do, obviously. Moreover, the inverted video does not capture the condition of the right rear tail light, and it conceals Trooper Proctor's presence by the right rear tail light. This leads to inescapable conclusion that ADA Lally's questions, Sergeant Buchanan's responses, and the deliberate introduction of inaccurate evidence was designed to perpetrate a fraud on the court, the jury, and misread with respect to a critical issue in the case. I mean, it's mind-blowing to think that like maybe they actually did that on purpose. It's hard for me to get there with my mind, and which I know will annoy a lot of people, but to think that when you saw it and you see it's inverted, that you wouldn't just have your tech guy flip it back is crazy to me. October 10th, 2024. Commonwealth produces additional exculpatory video surveillance footage in violation of Brady and Rule 14. Post-trial, on October 10th, the Commonwealth again provided new footage, this time from the CPD church side exterior, the first floor corridor, and rear lot cruiser side cameras. This footage shows Higgins arrive at the parking lot of the CPD at 1:26 a.m., enter the building, and speak to some identified individuals on the phone as he is leaving the CPD at 1:34 a.m. Significantly, this specifically requested material and relevant evidence, which establishes that Higgins was on the phone with some identified individual at 1:34 a.m. as he left the CPD shortly after O'Keefe's death, was suppressed until after the first trial. So here's the difference between the prosecution defense does not play by the same rules. Anybody who tells you they do is wrong. Now, there are certain rules that apply to everybody. But when it comes to a prosecutor, their duties and their ethics are supposed to be above and beyond anything that even comes across the defense's desk, because they don't have access to all of this. They control so much of the evidence. So the difference here with something being produced after the first trial, that again, first trial is done, it's gone, it's behind us, there's nothing we can do. So as far as the defense goes, the payment afterwards doesn't matter. It didn't happen at the time. What they said was true at the time. The difference is this potentially being introduced in the first trial, if it was exculpatory, does matter to the defense. And if Karen Reed would have lost, and this video clip, this is how I kind of look at it. If she would have been convicted and this video clip of Higgins on the phone comes out and the defense argues it's potentially exculpatory and it's Brady, and they use this as part of their appeal as newly discovered evidence, I think it's a pretty great argument to overturn a conviction. So when you look at it from that position, you start to see the difference between producing stuff afterwards and if it's exculpatory and Brady, how it makes a big difference when it's a prosecutor. The defendant has rights, and that's where some of the differences come in to how the rules apply to each side. And then there's some things redacted again. I don't know what they are. Mind in the Shadow said, I can't remember who, but someone testified that the timestamp on the Sallyport video they watched was yellow, but the one shown in court was blue, possibly another video they've not disclosed. I assume if the defense put that together, they would ask for it. But again, it's very hard to get into a situation where you're trying to tell the prosecutors what evidence they have, right? What exposure / fallout would ADA Lally and ADA McClell have due to the Rule 14 violations? Well, the remedies are you can be sanctioned. You can not be allowed to use certain pieces of evidence. You can be thrown off the case potentially if it's that bad. We saw that in the YNW Melly case. Like, it does happen. Curious what Funkos you have on the shelf there. A ton of stuff. We've done it in a members only video. If you go back and watch like my office tour, we break it down in there. Ain't so plain Jane. Yanetti's Karen Reed was framed should be the closing argument, hammering on the reasonable doubt, in my opinion. Charlie, a mirror image may be the exact, except for the fact that right is left and left is right. And the fact that the right side was mentioned is what negates it. Yeah, the questioning was really the issue. And yeah, we talked about the fact that if I say, this is my left hand, oh, I don't have a wedding ring on. You could learn something from that, when in reality, this is my left hand with my wedding ring on, right? But it may look different if it's mirrored in the camera. King Pine Worldwide, 12/4/24, Boston City Councilor Tania Anderson indicted by federal grand jury for alleged kickback scheme, obtaining thousands in cash in exchange for bonuses. Bev won't get her carrot for a dismissal. Okay. Commonwealth failed to preserve exculpatory video surveillance from January 29th. On November 8th, while preparing for Miss Reed's second trial and in response to the continued piecemeal production of video footage that had not been originally disclosed during the first trial, attorney Elizabeth Little emailed Special District Attorney Hank Brennan, again requesting all raw video footage from the CPD, which shall include, but is not limited to, all cameras capturing the interior of the CPD, exterior of the CPD, all parking areas, entrances, exits, garages between January 29th at 12 a.m. to 11:59 p.m. On November 25th, ADA Brennan indicated via email that he would request CPD provide all requested footage. Ultimately, the defense requested access to the CPD DVR system and drives that hold recordings from the security camera system so that the defense expert Matthew Erickson could obtain the video files, corresponding log files from the 29th on those times. Upon reaching an agreement with the Commonwealth, Kay discovered he went down there, he failed to preserve it. We talked about that when their expert went down there and couldn't get anything. January 29th, Commonwealth produces more exculpatory blurry video surveillance. It's still 2025 now, and they're still producing it. Way back in 2022, they were ordered to and compelled to. The Commonwealth produces more exculpatory blurry video surveillance footage establishing that an unidentified person approaches the right rear taillight of the SUV as soon as it enters the Sallyport garage. On January 28th, 2025, the Commonwealth yet again turned over additional CPD footage from 29th of 2022, this time from an exterior camera depicting Miss Reed's SUV being brought into the Sallyport garage. Main driveway side exterior Sallyport video is what it's called. The footage, although blurry and grainy, appears to show an individual approach the right rear taillight of Miss Reed's SUV immediately after the vehicle is brought into the Sallyport garage, and then exit shortly thereafter. If this video were not blurred out, the surveillance feed would have captured yet another angle of the right rear taillight as it entered the Sallyport garage. At a certain point, it defies logic that all CPD video surveillance footage coincidentally cuts out, blurs out, or becomes grainy at the precise time the rear taillight of the Lexus SUV should be in frame upon its arrival at the Sallyport. This angle of video surveillance is exculpatory and was withheld from the defense prior to the first trial. So at the very least, something I think if I was a judge and I really thought the Commonwealth didn't do anything wrong, what I would at least want is say, listen, Commonwealth, Lally, CPD, all of you guys get together, figure out who or however many officers it takes can come in and answer me these questions. Where did this stuff come from? Why is it in multiple clips? Why are parts of it grainy and blurry and other parts not? Why are parts missing? And if they can't answer any of those questions, it adds a lot of context to how you should look at this motion as a judge. If they really just tell you, oh, we don't know, Judge, we have no idea. We don't know why. They keep asking us for clips and just randomly will turn over another clip. Okay, somebody from CPD explain to me how that works logically. And by the way, as I'm reading through this motion, it's horrible. And I would feel the same way, even if the general public thought they have the right guy or they have the right gal. That's a guilty person sitting over there. Well, if the prosecution acted like this, and this is how the investigation was, this is not how it's supposed to be. And we're still violating people's rights, and we're still stepping on people's rights, and it matters. Whether you think somebody's framed, whether you think somebody's innocent, whether you think somebody's guilty, if the government and law enforcement and prosecutors and judges and whoever, if they can do this to people you think are guilty, then you shouldn't be outraged when they do it to somebody you think's innocent or somebody you think is framed. Because that starts to give them the power. That starts to give them the feeling that they're untouchable and they can do whatever they want. And oh, sure, yeah, go say the cops doctored a video. Nobody's going to believe that. That's where judges have to come in as the gatekeepers. And they can't allow this stuff to happen. They just can't. Not without explanation. And much better explanation than we've gotten in this case. Peter, the timestamp was not inverted. How is that explained? I don't know. And that's what I'm saying. I don't know. When we were watching that live, I was like, well, I don't understand this. I don't understand this. Now, I would think that the defense could call an expert that could say, like, this is how you would edit it. This is how you would do it. I don't know. It's not too far for me to imagine the video was presented reversed intentionally if you believe the corruption claimed by the defense. Yeah, the defense would say this tracks. That's what the defense would say. All right. January 29th, they turned over more. Did I already read this? Grainy. Yeah. All right. Facts relating to the Commonwealth's intentional withholding of exculpatory statements made by seminal witness Jennifer McCabe. McCabe is a key Commonwealth witness. Her credibility is critical to the Commonwealth's case. On February 2nd, mere days after O'Keefe's death, the MSP obtained and forensically imaged McCabe's cell phone. The forensic examination of McCabe's cell phone revealed significant exculpatory evidence supporting Ms. Reed's third-party culpability defense, establishing that Ms. McCabe Googled "How's long to die in the cold" at 2:27 a.m. on January 29, 2022, 3 hours before she supposedly discovered Mr. O'Keefe's hypothermic body in the snow on her brother-in-law Brian Albert's front lawn. McCabe then took steps to delete that one search out of more than 4,560 on her phone, along with nearly every communication made on her phone in the hours following O'Keefe's death, only some of which were recoverable from her phone using forensic extraction software. The close and long-standing relationship between the Albert and McCabe families and the law enforcement officers assigned to investigate the case is central to Ms. Reed's third-party culpability defense. CPD Sergeant Lank, a longtime friend of the Alberts, was the first officer to enter the Albert residence on the morning of January 29th. In preparation for trial, the defense uncovered the location of Ms. McCabe's cell phone, which provided she went to first responding officer Sergeant Lank's home on January 30th, 2022. So it's like, if the cops were investigating McCabe, they should have found this stuff and they should have turned it over to the defense. They clearly didn't. And this is not quite as black and white as not turning over the video or destroying videos or not preserving it, things like that. To me, they have an expert that says she didn't Google it at that time. So they're not going to turn over evidence that isn't reliable to the defense. Or the defense did have the download of Jen McCabe's phone, so they can do with that information as they want. The state doesn't have to hire an expert to create the defense for them, right? So again, this one's a little bit more there. I can see some arguments on both sides. On May 10th, 2024, in a then undocumented meeting, here's the issue. Lieutenant Tully, ADA Lally, and ADA McLaughlin met with McCabe shortly before she was scheduled to testify at the first trial. Why is Lieutenant Tully meeting with her? Why is Lieutenant Tully meeting with a witness before trial? The lawyers, you're never going to hear me complain about a lawyer prepping a witness. It's just how it happens. It's how it works. You talk through things so they don't get nervous. You prepare what you can't. There's a lot of cases where it's like, no, you cannot talk about this. The judge will instruct you cannot talk about this. That's important. So that happens in prep. McCabe testified on May 17th. This is a week before her testimony. This meeting happened that should have been disclosed. During cross-examination on May 21st, she testified that she received a text from her sister, Nicole Albert, on January 29th. We'll get more info tomorrow. Don't want to text about it. To which she responded, right. When McCabe was asked whether anything significant happened the next day, McCabe volunteered the following story. I went to the O'Keefe house. On the way home, Carrie Roberts' daughter is good friends with Michael Lank. So we dropped her off at Michael Lank's house, and Mike's wife came out of the house. Him and Carrie are friends, and she, jumped in the car and was consoling Carrie and asked how the O'Keefes were doing. And, we talked to her. She testified that she was at the house for approximately an hour and that she might have ran in to go to the bathroom. Then a redacted portion. On cross at the trial was the first time McCabe mentioned going to Sergeant Lank's home on January 30th, 2022. When pressed further, she admitted that she had discussed the issue at a meeting a couple weeks prior at the DA's office. She testified at the meeting at the DA's office. I was asked, oh, were you at Michael Lank's house on the 30th? She admitted, at first I said, no, I've never been to his house. Then I thought about it and I said, oh my gosh, yes, I did go there. And that was the extent of the conversation. She further testified that one, Tully did not ask her any follow-up questions about why she went to the personal home of Sergeant Lank the day after John O'Keefe's death. And two, he did not take any notes. So here's what I'll say. This is bad. This is not how it should happen. She's definitely fixing and changing her testimony. But in fairness, I would probably argue a lot of this prejudice was dealt with in this moment. Should the defense have had it beforehand? Yes. Should they have had time to prepare it? Yes. Is it potentially a Brady violation? Yes, I would say yes. They should have told them about it between May 10th and May 17th. Yes. But he got her to say on the stand that she changed her testimony. He got her to say on the stand that she didn't ever remember going to Lank's house. He got her to mention on the stand that she had a meeting with Tully, Lally, and McLaughlin. So a lot of the negative or prejudicial information did come out in front of the jury. So that is an important way to look at it and why this alone would not be enough to really make a mountain out of that's going to dismiss a case, in my opinion. Still not good, right? On May 29th, only after the defense was deprived of the opportunity to effectively cross-examine McCabe and Kerry Roberts about the visit to Lank's house, Lieutenant Tolley memorialized his meeting with McCabe. Tolley memorialized McCabe's inconsistent claim that she went to Lank's home to pick up Kerry Roberts' daughter. Lieutenant Tolley, May 29, 2024 report, which also admitted any reference to McCabe's exculpatory statement in which she denied that she ever went to Sergeant Lank's house, was not disclosed to the defense until June 4th, 2024. The report was not disclosed because she said it here. Right? All right. Then there's an entire section, right? Section C that's redacted. Hate to see that. Don't know what it is. All right. Now we get some argument. The Commonwealth has engaged in numerous Rule 14 violations and constitutional violations under Brady v. Maryland and its progeny. Ms. Reed's constitutional rights to effective assistance of counsel and due process under the law as guaranteed by Article 12 of the Massachusetts Declaration of Rights and the 6th and 14th Amendments of the United States Constitution require that the Commonwealth disclose certain evidence in advance of trial. Pursuant to Brady and its progeny, defense counsel is entitled, as a matter of due process, to all evidence that is favorable to the accused and material either to guilt or to punishment, including impeachment evidence and evidence necessary to place the witness in his proper setting and put the weight of his testimony and his credibility to the test. Brady disclosure also extends the disclosure of information useful to the defense to attack the reliability of the police investigation and the police methods employed in assembling the case. So in some cases, there's not a ton of Brady. Cases like this, Brady comes in big chunks and masses, right? Can you discuss how challenging it is for a prosecutor to have the family of the victim be involved in drama? Paul O'Keefe texting scandal. I don't know what the Paul O'Keefe texting scandal is, but it makes it difficult. Anytime there's anything negative about a victim, we'll talk about the ASAP Rocky case where ASAP really, a lot of negativity coming from that testimony, it makes your job harder. The inverted video was backward, no doubt, but how did the date not be if it had been manipulated? I don't know. Again, if this was my case, I would have to hire an expert to dig in and explain all of this. If hung again, you think it would get dismissed? Whose side is Whitney on, JB or BL? Haha. I don't think she is really loving either, if I'm being honest. I think she thinks it's like much ado about, maybe not much ado about nothing, but like, why are they doing this? It's really exploded. She doesn't think anybody's going to look great afterwards, which I think says something. Will it get dismissed? I don't know. A lot of cases get dismissed or worked out after one hung jury. Every time it gets hung, there's more of a chance of it to get worked out or dismissed. I'll say that. But this case, I'm not so sure. When will this be ruled on? I don't know. Whenever Judge Cannoni has time. How is it possible that this information does not cause this judge grave concern? Paula, I see what you did there, and I would agree with you. It should absolutely cause you grave concern. Now, the issue is she probably doesn't want to call the prosecutors liars. So to say you did know about this video and you're lying when you say, these parts trickled out, she probably doesn't want to do that, but it's really hard to understand how it's possible that this is how video surveillance taken from the same location that would have been saved at the same time in the same spot is trickling out and part of it's cut, blurry, snippets, grainy. I just don't get it. In addition to her constitutional rights, Ms. Reed also has a statutory right to obtain evidence in advance of the trial and prepare her defense. Massachusetts Rule of Criminal Procedure clearly states that the Commonwealth must provide certain mandatory and automatic discovery of evidence within the possession, custody, or control of the Commonwealth and the defense in order to meet its mandatory discovery obligations. Information subject to mandatory discovery includes all material and relevant police reports, photographs, tangible objects, all intended exhibits, reports, physical examinations of any person or of a scientific test or experiments, and statements of persons the party intends to call as witnesses. The Commonwealth is also required to provide any facts of an exculpatory nature. Additional rule for the Commonwealth, right? I mean, there are certain things the Commonwealth has to do, the defense doesn't have to do. It's just how it is. The rules also state that the defendant may move for discovery of other material and relevant evidence not required by subdivision A1. Here on February 2nd, 22, Commonwealth was ordered to preserve all evidence. Subsequently, on October 5th, they were compelled. Notably, this prosecutorial duty to produce evidence covered by Rule 14 extends beyond the prosecutor to all agents of the Commonwealth, including police. The prosecutor shall disclose information covered by mandatory discovery, provided it is in the possession, custody, or control of the prosecutor, persons under the prosecutor's direction or control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in the case. Prosecutor's duty to disclose exculpatory evidence extends to evidence in the possession of the police who participated in the investigation and preservation of the case. So we've seen, especially Hank Brennan as the special prosecutor, try to figure out a way to shield himself from what law enforcement did. I asked law enforcement, I asked them, this is what they told me. It's like, well, you are responsible for what law enforcement has as the prosecutor. The Warthog, maybe a dumb question, but why does stuff get redacted? Does the Commonwealth get to see the redacted portions? Why would you redact info? So yes, this one we were told is because of the federal protective order. That's why this gets redacted. Some things are, if it's about a minor, you may redact it. If it's about the jury, you may redact it. If it's necessary, if you go read Koberger, all those motions to seal, you'll see exactly why certain things get sealed or redacted. Miranda, Peter, have you ever seen a trial that has allowed for evidence like this? Not just the solo cups, but the video, the background conversations. Like, did they even try to do things by the book? Yes, unfortunately, I have seen trials that have horrible investigations. Maybe not all of this in one case like this one has, but these snippets, I have seen issues similar to this in the past. I am such medical doctors. One such medical doctors. Read Exhibit P, Alan Jackson's affidavit regarding Jen and Tully. I absolutely will if I have time. We will get to as much of this as we can if I have time. It's like 40 pages, though, of stuff. We're halfway through. Other stuff's redacted, but I'm going to do my best to get through at least the entire motion today. As set forth herein, the Commonwealth has repeatedly violated its discovery obligation under Brady v. Maryland. Commonwealth's production of the April 23rd inverted video from the CBD Sallyport garage violated Rule 14 and the court's order. First, the Commonwealth violated Rule 14 and the court's order compelling the video by withholding the inverted video from the Canton Sallyport until after the start of the trial and after the Commonwealth had already filed its certificate of compliance. And that's the point. It's like, did you withhold it? The Commonwealth's clearly going to say no. So how did you get it? And whoever gave it to you, what's the first time they saw it? Why did they access it? Why were they going back and looking for video? And why didn't they do it before? Did you tell them to do it before? You should have. You're required to tell them to do it before. You're responsible for it. So how did it just pop up out of thin air? Were you having people, and if their answer is, we constantly are having law enforcement scrub through everything we have on Karen Reed, search through all our documents, see if anything's saved anywhere else. And when we were doing that, we came across something we never saw before. That might be the best explanation they can have. Because anything else, it's like, that's not how it's supposed to happen. At best, the inverted video had been in the Commonwealth's constructive possession since January 29th. At worst, this video evidence was intentionally manipulated and inverted by the Commonwealth and its agents sometime thereafter in an effort to defraud the jury into believing that no law enforcement officer approached the rear right taillight. Either way, the Commonwealth's production of the inverted video in the middle of trial and after it had filed its certificate of compliance violated Rule 14. I agree. The Commonwealth violated Rule 14 and Brady by withholding exculpatory impeachment evidence. By the way, a lot of people have said this, but just also remember, I said it was wrong for the defense not to turn over the outline that was given to ARCA. And it was wrong for the defense to say they hadn't paid ARCA if, in fact, they had after the trial. Now, that payment does nothing to the first trial because it didn't happen. At the time he asked, they didn't pay him. So there's no prejudice there. And as far as the outline goes, the prejudice is minor at best because they testified to everything. They did the voir dire. They knew everything. Jackson didn't make his outline out of it, but the Commonwealth should have had the opportunity to say, you are biased, Dr. Wolf. You even sent him a list of things to ask on direct, didn't you? They should have been able to ask that question. So that's the amount of prejudice that existed for the discovery violation by the defense. And I'll say that, and I'll stick to that till the cows come home. But this is just so much worse, right? And dealing with all this during trial is not how it's supposed to be done. And that's not even an argument. Everybody agrees that's not how it's supposed to be done. That's why we have discovery cutoff dates. That's why we serve certificates of compliance. That's why the judge compels you to turn stuff over before trial, because it can't be a trial by ambush. That's the problem. They dealt with some of this and they mitigated it as much as they could, but this just violated all the rules. That's the problem here. Yes, I don't care. That's still something that should have been turned over. The outline, I just said that. Dr. Wolf provided the outline to the defense. The Commonwealth should have been able to ask Dr. Wolf that. Dr. Wolf, you say you're up there independent, unbiased. You provided Mr. Jackson this outline to help out with your direct today, didn't you? Should have been allowed to ask that question. They should have, period. They should have. All right. Commonwealth produced previously withheld video surveillance of CPD's church side, which had Higgins on the phone. The Commonwealth, namely ADA Lally and McLaughlin, suppressed exculpatory impeachment evidence. Any evidence which tends to impeach the credibility of a key prosecution witness is clearly exculpatory. There's no doubt about it. They should have been asking Higgins, you said you weren't on the phone. Who were you on the phone with? Who were you talking to? That's really important stuff, especially for a witness you're basically accusing of wrongdoing. That's really, really important stuff. The exculpatory video surveillance footage was in the Commonwealth's custody or control. By withholding it, failing to produce it, they violated Brady. Commonwealth violated Rule 14 and Brady by withholding exculpatory video evidence, establishing that an unidentified person had unfettered access to Miss Reed's right rear taillight of the SUV immediately after its arrival. This is the grainy video, I believe. Camera depicting Miss Reed's angle should have had a clear, unobstructed view. However, yet again, it's too blurry and grainy to make out the condition of the taillight. Notwithstanding that fact, the footage is exculpatory and shows an individual approach the rear taillight of Miss Reed's SUV immediately after the vehicle is brought into the Sally Port and then exit shortly thereafter. And this is a good indication about what is exculpatory, right? What is Brady? And to me, it doesn't have to be a video of Proctor walking up to the taillight with a sledgehammer, hammering the taillight. Okay? That's not what it has to be. Something that shows, even a grainy video of somebody walking up to that taillight, is exculpatory, is something the defense should be able to put before the jury and say, look, members of the jury, yet another opportunity for them to act like, for the prosecution to act like nobody could walk up and bust this taillight. Look at all the videos we have of people having access to this taillight, walking up, walking back, talking to their buddy about it. And it just so happens that all the police video is just too blurry to see exactly who it is or what they're doing. You're allowed to make that argument. It is your right as a defendant. Video surveillance has been in the Commonwealth's possession since January 29th, withheld from the defense, produced after trial. So again, I think they're assuming it's been in their possession or saying their constructive possession. Actually, you know what? It's not even an assumption. They're right. Because guess what? If I'm a prosecutor and a cop sends me a video, it's in the cop's possession. So unless the cop said, I drove over to Radio Shack and got this video and sent it over to you and it was in Radio Shack's possession, it's constructively in the prosecution's possession. If they eventually found it, fine. They can say they didn't have it, they didn't know where it was, but it existed in their possession and they should have found it before the first trial ended, clearly. Ms. Reed's defense of the trial was that law enforcement removed the taillight. No taillight material exists in a 34 Fairview. All right. The Commonwealth failed to preserve exculpatory evidence in violation of the court order. The court ordered them to preserve the evidence, the metadata, and the log files underpinning the CPD, which the defense still is trying to get. To be clear, the condition of the right rear taillight of the SUV at the time it entered law enforcement custody is perhaps one of the most critical parts of the case. The video files include a file capturing the interior of the Sallyport garage, the 42-minute gap missing, precisely the time the feed would have showed the unobstructed view of the right rear taillight of her 6,000-pound SUV. They love throwing that in there because it's a good part of their defense. It improperly depicts right as left and left as right. This is the inverted video. And it was not downloaded in a forensically sound way that could make it testable. It's a problem. Even if Lally was not actually aware of the footage, a reasonable prosecutor exercising due diligence would have been aware. ADA Lally had an ethical, statutory, and constitutional obligation to obtain this footage. Evidence in possession of police is Brady material, even if the prosecutor is unaware of it. So the prosecutor has constitutional duty of inquiry. And by the way, not all late disclosures are created equally. So if you say you don't have something and then you get it and you disclose it, it's not so simple as to just say, here it is. All right, let's continue on. Because then you would get rewarded for burying your head in the sand. If I just don't look for something, then I won't find it, right? If I was going to create a conspiracy and my buddy was in it and he said I did something on video, I'm not going to go look at those videos. Then I'm not going to have it. Then I'm not going to turn it over. That's just not how it works. And that's why you have to be a reasonable person and look and do your due diligence. You have to. You have to. I think Emily said during Baldwin that prosecution's lack of knowledge of exculpatory evidence isn't a defense against Brady. If police fail to provide the evidence, it's the same legally as withholding. So yes, but the police do have to have it, right? If a witness comes forward that nobody ever heard from, including the police and the prosecution, that's exculpatory, you don't hold that against the prosecution because they didn't know about it, right? So there are different levels of not knowing, right? Boston Breezy, Pizza, has your opinion changed at all? Do you still believe Karen Reed is innocent? Love your channel as always. I still believe from everything I've seen, the prosecution cannot prove beyond a reasonable doubt that Karen Reed hit John O'Keefe with her car. Therefore, my vote would be not guilty. But there's going to be a second trial, and we're going to see how the evidence is presented. We'll see if anything changes and what the Commonwealth experts say. If it's the same as Trooper Paul, I'm just not buying that. And logically and scientifically, that makes no sense. And I think Karen Reed's experts make complete scientific sense. Peter, how often do discovery violations occur? I mean, technical discovery violations, more than 50% of cases, I would say, especially like what I would say is a discovery violation in cases against me. I think it happens all the time. But this bad, very, very few. I think the video was inverted, footage was spliced out, and the timestamp added after the fact. Yeah, I mean, I don't know. I think it's hard to prove, right? But with context, I think it fits into the defense's argument. Radio Shack, what's that? You know, I remember that. I think I bought like remote control cars for Radio Shack back in the day. Honey Bunny, could the defense call rebuttal witnesses to explain to the jury standard protocol, policy, and procedure of police investigation to compare and contrast incompetence, bias, corruption? I have seen cases, and we've had cases where we call experts on how police investigate cases. I think that would help here just to show exactly. I mean, I think we saw it in Melly's case. I think they had somebody do that. All right, let's get back to it here. The Commonwealth withheld exculpatory statements by McCabe in flagrant violation of Brady, in which she denied traveling to the personal residence of first responding officer Lank on January 30th. Then she claimed she went there with Carrie Roberts to pick up Roberts' daughter. Clearly, the Commonwealth was required, pursuant to Rule 14, discovery obligations, to disclose the false statement made by McCabe to Lieutenant Tully. So basically, they have a meeting. She says something that's not true. They need to tell the defense so that they can dig into it with her and create a statement that is inconsistent for a material witness for the Commonwealth. And they're right. All statements, especially ones that impeach, are exculpatory, clear-cut Brady violation. They're right. They're right. They're stacking these on top of each other. The Commonwealth's egregious and repeated discovery and Brady violations require dismissal of this case with prejudice. When the Commonwealth fails to comply with its discovery obligations, the court has the ability to impose remedial sanctions. For failure to comply with any discovery order issued or imposed pursuant to this rule, the court may make a further order for discovery, grant a continuance, or enter such order as deemed just under the circumstances. So again, if she finds these violations, she can say, you better turn it over now. Here's another order. And if you don't, I'm going to sanction you. She can say, I'm going to continue this trial because of this discovery violation. She can say, You can't use this piece of evidence because it's a discovery violation and you didn't turn it over in time. Again, that doesn't work with exculpatory evidence. But like we said, experts and things that you do want to use. Or fourth, this is so bad, like we saw in Alec Baldwin, throwing it out. Possible orders include dismissal of charges with or without prejudice. He mentions them here. Some remedies: exclusion of evidence, dismissal of charges. Dismissal is appropriate as a remedial sanction as a way to cure any prejudice caused by the violation of a discovery obligation and ensure a fair trial. Again, with the rules being different. The defense violates discovery. You don't dismiss the case, right? It's different. It's a different world. Prosecutors have different standards, and they must, because of we're seeing and learning throughout these years of covering cases and talking about them with you guys. I know you're getting this more and more, and you're getting this understanding, living it, seeing it, breathing it, how much power prosecutors have to ruin people's lives, to promote, seek, and get justice, right? To do the right thing or do the wrong thing. So much power is in their hands. Such a drastic remedy would be appropriate where failure to comply with discovery procedures results in irremediable harm to a defendant that prevents the possibility of a fair trial. So this is the big question for Judge Cannoni. Is this so bad that the most drastic remedy you can have against a prosecutor should happen? Because it's impossible to get a fair trial. Are we there? The Supreme Judicial Court has identified two parallel legal principles governing when dismissal might be necessary, balancing the rights of defendants against the necessity for preserving society's interest in the administration of justice. First, where the prosecutor fails to disclose evidence the defendant is entitled to receive and the defendant is prejudiced by the failure to disclose, a motion to dismiss should be allowed when the defendant can make a showing of irremediable harm to the defendant's opportunity to obtain a fair trial. Do you think they're going to be able to convince Judge Cannoni that we're here? Alternatively, prosecutorial misconduct that is egregious, deliberate, and intentional, or that results in a violation of constitutional rights may give rise to presumptive prejudice. In such circumstances, dismissal would be appropriate if needed to create a climate adverse to the repetition of that misconduct that would not otherwise exist. So judges can also get creative, right? We saw Judge Boyce in Lori Vallow's case when he felt like maybe speedy trial rights were violated, maybe there were issues. I'm going to take the death penalty off the table. So could Judge Cannoni just potentially dismiss the highest count because these discovery violations? Logically, that really wouldn't make sense, right? If she was going to do that, it would have made more sense to do it based off what we heard from the jurors. But judges can potentially get creative with things. I wouldn't expect it, but it's possible. Dismissal is the only appropriate remedy for the Commonwealth's egregious and repeated non-compliance with discovery obligations. Given the extreme governmental misconduct in this case and the irreparable nature of the harm to Ms. Reed as a result, dismissal is appropriate and necessary under both legal principles outlined by the Supreme Judicial Court. The Commonwealth has failed to disclose evidence that it was obligated to disclose to Ms. Reed, which severely prejudiced her such that a fair trial is impossible. Here, Ms. Reed has been irreparably prejudiced by the Commonwealth's discovery violations. First trial related in a hung jury, precisely because this was a closed case. Had the Commonwealth produced the exculpatory footage and exculpatory statements to which Ms. Reed was constitutionally and statutorily entitled, the result of the trial may very well have been different. Instead, the Commonwealth engaged in repeated instances of withholding exculpatory information from the defense in a concerted effort to undermine the defense's ability to effectively confront and cross-examine the Commonwealth's seminal witnesses in this case, including Buchanan, McCabe, Higgins. Moreover, the Commonwealth's continued piecemeal production of exculpatory video footage, which has, by definition, been in the Commonwealth's possession since January 29, 2022, is a flagrant violation of the Commonwealth's constitutional and statutory obligations under Rule 14 and Brady. It is well established that suppression by prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. The Commonwealth may not withhold such evidence from the defense. To do so is not only a discovery violation under Rule 14, but also a constitutional violation. Furthermore, the Commonwealth's gamesmanship in withholding the exculpatory video surveillance footage, and again, they would say it's not gamesmanship. The Commonwealth would say we just didn't have it. and failing to properly preserve this exculpatory evidence has irreparably harmed Miss Reed. To this day, the Commonwealth has not produced all of the video surveillance footage recorded at the CPD on January 29, 22. Numerous camera angles and large swaths of time are missing as a result of the Commonwealth's failure to appropriately image and preserve this evidence. Video surveillance footage, which should have captured the condition of Miss Reed's rear tail light at the time it was taken into police custody from multiple cameras at multiple angles, has now been destroyed forever. Absent the destruction of this evidence, which has been in the possession of the Commonwealth and its agents since January 29th, the defense would have conclusive evidence that Miss Reed's taillight was cracked, not shattered, when it arrived at the conflicted CPD on January 20, 2022. If the taillight was largely intact and only cracked rather than shattered and missing 47 pieces, as Dighton Police Office Sergeant Barrows testified he observed earlier that day. That evidence would establish, after the Commonwealth had claimed Miss Reed had struck Mr. O'Keefe, that evidence would establish Miss Reed's innocence and be case ending for the Commonwealth. It should not be lost on this court that the video surveillance was destroyed in the Commonwealth's possession in direct violation of a preservation order. So here's what I'll say. This whole argument that it would prove her innocence, that it would show it was only cracked, that the defense is 100% right, and we know what the video shows without watching it, that's argument. That's not something the judge has to necessarily take the way the defense puts it. But what I will say is, all of this to me, and I don't know if I would assume the defense has asked for it. I don't know if Massachusetts does things differently. Maybe they don't have these kinds of jury instructions or comments that the judge can make to the jury. But this seems, at the very least, a good remedy would be a judicial instruction to the jury that this video was in the Commonwealth's possession and control. And these edits and blurry and grainy sections, if they're held against somebody, should be held against the Commonwealth. Something to that effect. That they didn't preserve it appropriately. The fact that it's just popping up and being turned over now, to me, is evidence that this negative inference that the jury could take against the Commonwealth should be taken based on these videos, at the very least. As a result, Ms. Reed is left without the ability to forensically examine the CPD's DVR system to determine whether the many random clips produced by the Commonwealth and Discovery have been altered, manipulated, or tampered with, and whether other clips have been destroyed. Again, we don't want to overtry a case. You don't want to make a case boring. I keep saying again. But this is another expert. Maybe you asked Mr. Green this. These videos, or I guess no, he's like a Google expert. The expert that they sent to download the data is probably the guy that would have to answer this. More money. But you tried to download this, right? You would be able to see if something was altered, right? But the way the cops gave it to you, you couldn't do that, right? It was given to you in a way that you couldn't test. I think that's a good question to ask in front of the jury. The Commonwealth's failure to preserve and produce the evidence, which includes destruction of all original and native video surveillance footage and the accompanying log files, has irreparably harmed Ms. Reed. There is no lesser sanction that can cure the Commonwealth's failure to preserve this evidence. Exclusion of the video surveillance footage at trial would undermine Ms. Reed's defense because the footage itself is exculpatory. That's where he's saying, like, just striking this evidence doesn't help us, it helps the Commonwealth. The exculpatory evidence to which Ms. Reed is constitutionally entitled is permanently lost. Therefore, the Commonwealth's misconduct can be remedied only by dismissal of the case. Even if the court disagrees that Ms. Reed has been irreparably harmed, the Commonwealth's misconduct give rise to presumptive prejudice that warrants dismissal. The misconduct by the Commonwealth in this case was egregious, deliberate, and intentional. There were not innocent mistakes. The repeated and flagrant discovery violations engaged in by the Commonwealth and its agents were intentional and designed to bring about a wrongful conviction. Here at trial, ADA Lally, the Commonwealth and its agents intentionally withheld video surveillance footage from January 29, 2022. The Commonwealth sprung inverted surveillance footage on the defense in the middle of trial in violation of Rule 14, as well as its certificate of compliance. And then it compounded the violations by attempting to perpetrate a fraud on this court and this jury. By knowingly eliciting false testimony from Sergeant Buchanan on direct examination, the Commonwealth violated the ethical prohibition against presenting knowingly false evidence to the trier of fact. That's the point. Lally would have to say, I was confused. I didn't realize. I thought it was what it was. Or I guess he's going to stick to mirrored imaging is true and accurate in the same. The inverted footage of Miss Reed's vehicle from this interior Sally Port camera was an unquestionably false account of the true facts, and the Commonwealth passed it off as an accurate description of the SUV when it arrived at the CPD on January 29th, and that, as seen in the video, no law enforcement officer approached the rear right taillight. The Commonwealth's deliberate attempt to use discovery violations to its advantage in an effort to perpetrate a fraud on the jury is the precise type of conduct that requires dismissal. Moreover, both ADA Lally and ADA McLaughlin were caught withholding exculpatory information from the defense at the first trial. The Commonwealth's underhanded decision to surreptitiously reveal impeachment evidence to McCabe in advance of her trial testimony and then withhold her exculpatory statements to law enforcement is a gross violation of the Commonwealth's constitutional obligations under Brady and its progeny. Even after the trial, ADA Brennan located exculpatory video footage which was withheld from the defense at the first trial and established that Higgins made a phone call at 1:34 a.m. outside of CPD. This exculpatory impeachment material was never turned over to the defense. And a little redaction. The Commonwealth's repeated violations of its constitutional and statutory discovery obligations were calculated and intentional and were done in an effort to secure conviction at all costs rather than pursue the truth and justice. We're over an hour here, so everybody hit the like button. I'm going to answer some questions. We are going to get through this, at least the entire motion, the 36 pages or whatever it is. With regard to a defendant's right to a fair trial, does it matter if a procedural error was intentional, neglectful, or unintentional, or pretty black and white? It does matter. If it's intentional, it's even worse. And if it's intentional, the lawyer personally will get some potential sanctions, and the punishments are harsher. But even neglectful or unintentional actions can result in a dismissal if they do violate the constitutional rights of the defendant. Alert One Systems. My professional theory is they download the video onto a PC from the NVR, played it back on a media player, and used a screen capture to record it at a lower resolution, and then inverted it, no metadata. So I get what you're saying here. My small brain, especially when it comes to tech, like I've taken a picture of something on somebody's phone before, or recorded somebody, or taken a picture on my computer. So I get it, and I get how that makes it worse, but that would mean somebody has the original video, right? And that's what the defense is trying to get to. Boston Breezy RN. Anyone talking smack about Peter needs to understand he is never going to name call or be disrespectful towards an attorney on this case. Most of us enjoy his unbiased point of view. Thanks for all your work, Peter. Thank you. Yeah, that's not what this channel is. There's plenty of channels out there, right? If that's your fancy, there's plenty of channels out there that will go at everybody personally and call everybody names, and it is what it is, right? And there's an audience for that. This ain't it. This ain't it. I'm looking at this legitimately if I was the judge, if I was the prosecutor, if I was the defense lawyer, putting on all those hats throughout this process. If I was the judge, I'll just say it now. If I was the judge, I would dismiss this case. There's 17 different reasons and ways I would dismiss this case. If I was the prosecutor, I would not prosecute this case. If I was the defense attorneys, I would file these same similar or very similar motions to this. That's how I'm looking at this case. Does that mean I know for a fact the conspiracy is true and that she absolutely didn't do this? No. But the evidence that's presented and the way the law works and the way reasonable doubt works, it's really not a close call. The way misconduct works, it's not a close call. The way the pursuit of justice as a prosecutor, if you know 12 jurors voted no on a charge, you should dismiss at the very least that charge or those charges. Hey, Peter. Love the idea that judges can be creative, but Judge C is not going to get creative. Do you honestly see anything coming from this? So I was going to wait till the end, but since you gifted 5 memberships, Bob, I'll tell you now. Do I think Judge Cannoni is going to dismiss this case based on this motion? Absolutely not. If I was putting it at a percentage of my confidence, I would say I have a 98% confidence rating that she will not dismiss this case based on this motion. Jen, do judges receive backlash if they dismiss a case due to prosecution misconduct? Yeah, they can. They work every day with prosecutors. Prosecutors can help get judges elected or put forth their opposition. A lot of prosecutors become judges. A lot of prosecutors used to work with, or a lot of judges used to work with these prosecutors. A lot of their mentors, people they used to work for, former supervisors, are in the prosecutor's office. So there's a lot of connections. So it's a big deal if they were to make a step like that. I'm behind, so I don't know if this has been addressed. Amateur video editor here. You can use masking editing tools to omit the original timestamp, invert the video, and create new timestamp. Not inverted looks legit. Yeah, I think even those of us that are like me that are not like you and don't have this experience and knowledge understand it can be done, but are there ways to look at it and see if it has been done? I don't know. All right, let me take a sip here. Did everybody hit the like button here for some extra go time, And I'm assuming everybody's subscribed by now. If you're not, please hit the subscribe button. I want you coming back and continuing this conversation. I like seeing the same names. I like seeing the comments and the positions change or get stronger, right, in the camp that you're in. Commonwealth's misconduct has resulted in a violation of her constitutional rights, give rise to presumptive prejudice. Discovery violations constitute Brady violation. To prove a Brady violation, the defendant must demonstrate that the evidence actually existed, the evidence would have tended to exculpate the defendant, and that the Commonwealth failed to disclose it upon proper request, which they went through those steps. Given that these facts give rise to presumptive prejudice and considering the need to create a climate adverse to repetition of that misconduct, this case should be dismissed. To allow this case to proceed to trial would create a climate in which these types of flagrant constitutional and statutory violations are regarded as permissible. Such an outcome cannot be tolerated by this court. And that's what I'm saying. If you let it happen to the worst of us, that means it's going to happen to the best of us. The Commonwealth's clear, repeated, and intentional failure to comply with discovery orders requires an appropriate remedy in this case. Because the discovery violations concern a failure to produce and preserve exculpatory evidence, and because exclusion cannot remedy the violation, the only appropriate remedy is dismissal of the case. Because of the Commonwealth's egregious misconduct, including repeated and intentional delays in providing discovery, the withholding of material and exculpatory evidence, and failure to comply with court orders regarding discovery, Ms. Reed's constitutional right to a fair trial has been irreparably and irreversibly harmed. No proceeding against her can satisfy the constitutional requirements of a fair trial. The defendant, therefore, respectfully requests this honorable court to order that the case be dismissed with prejudice. Dismissal is the only appropriate remedy for the violation of Ms. Reed's Sixth Amendment right to trial by an impartial jury. And here comes more redactions and all of my questions, basically. What is this about? I would love to know. Now, we know that a lot of the jurors came out. A lot of the jurors spoke to the defense. They wanted to speak to the Commonwealth, but I recollect some of them saying I didn't want to because they basically said they were going to publicly put out the names of the people that came and talked to them. And so I don't know what this is stemming from. We've obviously seen juror interviews online. Additionally, dismissal of this case is also required remedy. Dismissal of this case is also required to remedy the violation of Ms. Reed's Sixth Amendment right to an impartial jury. And then a lot of redacted stuff. Notably, a juror may never be dismissed because of their views on the case or for reasons having to do with their relationship with another juror. Instead, jurors may only be dismissed for reasons personal to the juror that have nothing to do with those views on the case or relationship with other jurors. They cite a bunch of different cases. Jury tampering, then blacked out, then jury tampering such as this is presumptively prejudicial. See Remmer v. United States. And Andrea Burkhart, I saw pop up on my timeline that she said, and so I looked up this case. This case is about, and let me pull it up here real quick just so we can talk about the facts. After the jury returned its verdict, the petitioner the petitioner was convicted by a jury on several counts of charging willful evasion of the payment of federal income taxes, a matter admitted by the government to have been handled by the trial court in a manner that may have been prejudicial to the petitioner and therefore confessed as error is presented. Okay, sorry. Let's see where the facts are. After the jury had returned its verdict, the petitioner learned for the first time that during the trial, a person unnamed had communicated with a certain juror who afterwards became the jury foreman and remarked to him that he could profit by bringing in a verdict favorable to the petitioner. So somebody came up to a juror and said, hey, if you get on the petitioner's side, maybe you can profit from this. And then that person that was spoken to became the foreperson. The juror reported the incident to the judge. They did the right thing, who informed the prosecuting attorneys and advised with them. As a result, The FBI was requested to make an investigation and report, which was accordingly done. The FBI report was considered by the judge and the prosecutors alone, and they apparently concluded the statement to the juror was made in jest, and nothing further was done or said about the matter. But they didn't tell the defense till after trial, and guess what? This case was reversed and remanded, and it went back to actually for a hearing and to get further information. But imagine that. Somebody talking to a juror, just talking to the prosecutor and the judge about it, not telling the defense about it, and then that juror who was said, hey, you could profit off of this, oh, he was just joking, and you never tell the defense about it, and they become the foreman. So how that correlates with the facts in this case, I don't know. But Andrea pointed that out. I wanted to make sure to make her point here on this video because I thought it was a good one. I don't know, but that's the case they cited. That's the Remmer case. So how does that apply to this case in Karen Reed? I don't know. Jury tampering such as this is presumptively prejudicial and triggers a burden on the government to prove that the tampering was harmless to the defendant. So the government has to prove the tampering was harmless to the defendant. What is the jury tampering in this case? I don't know. Heard some things. Don't really want to go on like what I've heard secondhand or actually even firsthand in certain scenarios. But there are things brewing with the jury that I'm sure you guys have talked about or heard about that I'm wondering which one has enough legs to get into a motion to dismiss by the defense. I really want to know. If I could just pick one part to be redacted, it would be unredacted, it would be this. As per Massachusetts law, courts do have the discretion to dismiss jurors when doing so would be in the interest of justice. Judges can do this at any time during the trial process, although the procedural burden and standard vary at various stages. So that gives context that this might be about certain jurors that were dismissed during the trial. Now, were they the ones that were dismissed during the trial? Were they the ones that were alternates that weren't picked to deliberate? I'd like more context. Post-impanelment, but pre-deliberation, if a judge is alerted to potential misconduct of or affecting jurors, the judge first determines whether the material raises a serious question of possible prejudice. If she so determines, she must then hold a hearing to inquire further into the alleged misconduct. Again, probably them saying, here's what happened in this case, judge, and we didn't do it the way we were supposed to do it in this case. Ultimately, Ms. Reed's Sixth Amendment right to an impartial jury entitles her to certain procedural protections when it comes to dismissal of jurors. Those procedural protections were not provided here. These constitutional violations, along with the egregious discovery violations discussed above, demonstrate the inherent unfairness of the proceedings against Ms. Reed and warrant dismissal of the case against her. So, while this is of great interest to me, one of the questions I would have is, one of the remedies of this would be a new trial, right? Again, if Karen Reed was convicted, we found this out and it was horrible, they could remand it for a new trial. We already have a new trial. We already have a second trial. So if there was juror misconduct, how does that apply to this dismissal? The only way I can really see it being part of this dismissal is if somebody in law enforcement or somebody on the prosecution team was involved in whatever this juror misconduct was, or if the juror misconduct was not provided to the defense and the prosecutors knew about it, then again, that can go with the prosecutorial misconduct potentially. But they would have to connect it in somehow. And I don't know the answer. Conclusion. For the above reasons, Ms. Reed respectfully requests that this honorable court grant defendants motion to dismiss for extraordinary governmental misconduct with prejudice. Although dismissal is required and appropriate under the circumstances, in the alternative, the defense seeks and is entitled to an evidentiary hearing on these issues attendant to the Brady violations and juror interference. So maybe they'll get somebody from law enforcement that says, explain to me how this works. How did we get chunks of this video? And then also the juror interference. Is that with a bailiff? I don't know. Court clerk? We've seen that before. I don't know. That evidentiary hearing will require testimony from a number of witnesses, including but not limited to ADA Lally, ouch, ADA McLaughlin, ouch, ADA Brennan, Lieutenant Tully, Chief Rafferty, Trooper Proctor, Sergeant Buchanan, Colleen Crawford, and other members of CPD and Lieutenant Fanning. I don't know. Affidavit of Jackson. How long is this? All right, we can get through this. I think. Let me answer some questions, and then this will be the last thing we do here. They can't dismiss and will allow to get her found guilty so they don't go broke when she sues. Not a bad point. Livy, how might AJ's ARCA bill get him possibly thrown off the case, but these huge violations will most likely get dismissed? How is that fair? It's up to the judge to balance fairness, right? I wouldn't do it that way. Your comment is definitely not how I would do it. So hard to answer. EDB also said she would not prosecute the case. She was a prosecutor for a lot longer than I was and was never a defense attorney. So it means even more. It seems like maybe some of the redacted stuff is details about jurors. Yeah, that's possible. That is absolutely possible. Dave, theoretically, if they could prove the DA and or police intentionally submitted false evidence to put someone away for life, what are the penalties? Like, I see no difference in taking a life. I agree. The penalties are they can go to prison, they can get sued, and even the government and the authorities, and they can just pay millions and millions of dollars. It's police misconduct, right? It's just like police beating up people. Things like this, they're absolutely criminal and civil penalties. They lose their job, et cetera, et cetera. Breezy. If Bev does dismiss, and it should be, if they go above her, and if so, could Bev be in trouble? So the higher court's not going to dismiss the case at this point, but these things will become issues on appeal, in my opinion, if she denies this. These are going to be arguments they make if Karen Reed loses on appeal. Hey, Peter, is this a situation where one thing needs to be bad enough, or is it cumulative? Both, or either. If one thing's bad enough, you get rid of it. But if there's so much as to where this just can't be a fair trial, that's also enough. So it all depends. Could they look at videos in the same location made prior and see if they are inverted? Would that be outside the scope of the discovery requested? So again, that's something that costs a lot of money. You get experts, but I think it's possible. I like where your head's going. It's like, okay, why is this one video inverted and this one not? Why is this one blurry and this one not? Somebody should be able to explain it at law enforcement. Their tech guy or gal there, right? And if they can't, it's just, this is stuff that the jury needs to understand how bad it is. Remember, the foreman was directly appointed as such by the judge. And I've heard maybe has law enforcement background or connections. I get it. I don't know what it is, though. All right, let's get to the rest here. Affidavit of Jackson, I'm a partner. I submit this affidavit. I've reviewed the discovery. The facts in the motion are correct to the best of his knowledge. Exhibit A is, okay, so we have court orders here. Is that all this is? True and accurate copies of the transcripts. Okay. These exhibits are true and correct copies of the video surveillance footage. So he's attached all of that. All right, Exhibit P. Okay, that's the one. Attached Exhibit P, copy of Tully's report. All right, how long is it? Let's see. Let's see what it looks like. Because that looks like it's just all saying... A, B, C, D, F, G, H, L, M, N, O, P, Q, R, S. Okay. L, M, N. All redacted. O. P. All right. 119. Oh, it's just one page? Oh, one pager? I am one such medical doctor. I love it. I love when somebody asks me to read something that's only one page. All right, here we go. Exhibit P. First Assistant District Lynn Belland, Detective Lieutenant Brian Tully, meeting with Jennifer and Matthew McCabe. On May 10th, 2024, Jennifer and Matthew McCabe arrived at the office of the Norfolk District Attorney's Office. Jennifer was provided a copy of her grand jury testimony regarding the Commonwealth v. Karen Reed. Matthew was provided of a copy of his testimony. They read the transcripts in a conference room and returned the documents. Jennifer requested to listen to her 911 call to Canton Police on January 29, 22. I played the audio file. Jennifer and Matthew requested to watch Canton Police cruiser camera video that depicts them both on the morning of January 29th. I played the portion of the cruiser camera that depicts the McCabes on that date. I asked Jennifer why her cell phone would have been in the area of residence of Michael Lenk, Canton Police Sergeant. Jennifer said she was with Carrie Roberts, who was picking up her daughter at the residence. Jennifer stated she did not speak with Michael Lenk while at the residence. Okay. I mean, this is just, all of this to me is like a lesson in what not to do as prosecutors. Unfortunately, we've seen a lot of that, right? The ASAP Rocky trial and then this. There's just so much here that's so bad. And at one point, we talked a lot about like the investigation is so bad. Can't go forward, too much reasonable doubt because the investigation is so bad. Well, when the prosecution of the case and the actions of the prosecution and the pretrial litigation of a case is so bad, it needs to get dismissed. And that's what the defense is trying to say where we're at here. Deja vu trial 2. If Karen loses and it goes to appeal, if the appeal is won, would Bev still be the judge? Depends. Depends if she's retired, transferred out, new judge in, if they specially appoint her to handle this because so much has gone on and it'd be too hard for a new judge to get up to speed. It's not a guarantee, I'll put it that way. Forrest Dump. If Bev does not dismiss the motion and decides to have an evidentiary hearing and then dismisses the motion, can they appeal her ruling? If she dismisses it after the evidentiary hearing, then it's dismissed. And that would be it. They wouldn't want to appeal it. If they disagree with her final decision, if the defense disagrees with her final decision and the reasonings for it, they go to trial, they lose, they can still file a motion with some of these arguments in them. I do think some of the discussions will be a moot point, like jury tampering in trial 1 when you're appealing trial 2. But all right, that's it, folks. That's it. We went some overtime again. Hopefully you guys enjoyed the video. Hopefully you learned something. I know I did as I read through this with you guys. Love seeing your comments and your questions on it. I go back and read a lot of them. When it comes to this case, I got to skip a lot of them too. I just a little, some eye rolls here and there at some of the comments, but I really like reading them. So hopefully they don't get so bad that one day I never read any of the comments, because I do hear a lot of content creators that do that and they say it's just better for their mental health. But I really love the interaction and hear what the awesome people that follow and subscribe and like the videos have to say and how they view this stuff. I just learned so much from it. I don't think I'll ever stop. I don't want to. So I appreciate you guys so much for being here. If you're not a member, we're doing a kind of a fun members only live tomorrow morning. So join the membership. I'm going to answer some questions, tell you some fun stuff we're kind of doing at the firm, and then give you a little tour of my newest addition at the house that is something near and dear to my heart that I love. So you guys can partake in that with me and we can hang out for an hour tomorrow if you want to. If not, I will see you on the next live. So until then, take it easy. I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.